I have the honor of introducing Judge Lynn Edelman, who is the moderator for our next panel. Many of you know Judge Edelman. He serves on the U.S. District Court for the Eastern District of Wisconsin, and his 20th anniversary on that court will be later this year. Before that, Judge Edelman spent 20 years in the Wisconsin State Senate, where he did a number of important and groundbreaking things, including chairing the Judiciary Committee for a number of years. I'm very excited to see what the next 20 years bring, as there seems to be a 20-year cycle. The other thing what I'm going to tell you that you might not know about Judge Edelman, because there's a bio in the program, but what I'm going to tell you that you might not realize is that it's probably the case that we're in this room today because of Judge Edelman. Judge Edelman has been a stalwart supporter of ACS. And just to give two examples, though there are many others, the Milwaukee lawyer chapter that Craig leads is really up and running today because of Judge Edelman, who called Craig and told Craig that it was time to revitalize the Milwaukee chapter. There hadn't been a chapter here that was doing active programming and work in too long, and Craig said no, and Judge Edelman called again, and Craig said no, and Judge Edelman kept calling. And here we are. Craig's doing amazing work. The Milwaukee lawyer chapter is doing amazing work, and it's because of that that we are all able to gather here in Milwaukee. It's also the case that Judge Edelman has been a great friend to our chapter in Madison, which started around the same time that the Milwaukee chapter revitalized. For those who are enjoying the unseasonably warm fall weather, it might be hard to imagine, but Judge Edelman came eagerly to Madison to do a program for us, and he chose, or agreed at least, to visit Madison in February, which is really above and beyond the call of duty. So we are all grateful to him and looking forward to this panel.
Well, thanks Jeff. And welcome to this panel, which has, I guess, a couple subjects. One subject is path to the judiciary, and basically I'm going to introduce the panelists, and they're going to talk about their experiences and how they got to be a judge. I don't know that we'll say too much more about that. You know, people ask me how I got to be a judge, and I just say, well, it was on the merits. But anyway, and then the other topic we're going to talk about is the state of the judiciary, and that's kind of a broad subject, and I know each of our panelists has something, a lot to say, and then we'll open it up for questions for maybe the last 15 minutes. So right now, I want to introduce our panelists, and each one of them will talk for a while about their particular position they hold and how they got there. Let me start with Mary Jane Tice, who's a justice on the Supreme Court of Illinois. And we thank Justice Tice for coming up here to Wisconsin today, and take it away.
Well, thank you. I'm thrilled to be here. Yes, I'm from Chicago, but I have strong, long-term Milwaukee familial relationships. Spent a lot of time here with my father and his cousins, and my dad went to Marquette, and all of those kind of things together, so I feel very happy to be here in Milwaukee. So I'm supposed to talk about my own I talked about my dad, and my dad was a lawyer and a judge. And before he was a judge, like some of the other folks you're going to meet here, he was involved in the state legislature for many years, and then became a judge. So in my life, I don't think I knew I was going to be a judge. I knew that I was going to be a lawyer, that I wanted to do something right. And I knew I wanted to do public service. And this is my family tradition, and I may not have been told that. I just sort of realized that from my history that I wanted to do public service. When I finished law school, I was a Cook County public defender, and I'm so glad I had that experience. My life is really easy. I got a great life, pay off being 7 grandchildren, but my life is very easy. And yet, for 10 years, I was very intimate in the lives of people who were suffering, and, whether they were victims or defendants or families. deal about life and about the human condition that I missed and did not have that opportunity. I hope I serve them well. I know that their stories stay. And then, I'm the kind of person that I was right at the curve, right when social change was happening, and suddenly people said, hey, there are women out there. They should be part of the legal system. And I was very fortunate for them to become a trial court judge in Cook County. I was first assigned to criminal cases, because that was my background, and then later I did complex cases. And after doing that for 10 years, I joined the Illinois Appellate Court. So for 17 years, I was involved in the reviewing court system, very different, setting up and cross-examining witnesses. And then after 17 years on our intermediate court review, in our state, when there's a vacancy, a judicial vacancy, the Supreme Court appoints, and then there is a partisan election that follows in the next cycle. Our Chief Justice became ill very quickly and retired, and the Supreme Court appointed me to take this position on the court. And then I ran for election and I was elected to that position. So, I'm not asking you to do the math, but I've been a judge for over half my life. I've been more judge than not judge. So, issues about the judiciary are very important to me, and that's why I'm going to be part of this meeting.
Thank you, Justice Tice. Our next speaker is Magistrate Judge Nancy Joseph, who is works with me in the federal court on Wisconsin Avenue. And Nancy has a very interesting story about how she got to be a judge. And I guess I'd like her to share it.
Thank you, Judge Adelman. Good morning, everyone.
Good morning.
I'm very happy to be here. It's nice to see a lot of familiar faces in the room. I see some friends, so that's nice, and hopefully some new friends as well. Like the title of my story is titled Little Girl from Haiti with no parents who were educated and being the benefit. That's the short version of it. And I'm writing the book, I guess, and then we'll publish it, and then the movie will be on Netflix. Oh, plays me, wow. I was born in Haiti. I came to the U.S. when I was 8 years old, one of 10 children. And as I mentioned, my parents didn't have very little education and didn't grow up in the U.S., but through a lot of luck, I ended up going to college and had some mentors and teachers point me along the way and told me, yeah, you should be a lawyer. And I was lucky to go to law school and become a lawyer. I began my career as a state public defender. Thanks to some state public defenders and also here in this room, I'm happy to see. I started at the juvenile court. Back in the day, juveniles had a right to a jury trial. Do you guys remember that? In the state of Wisconsin? And that was a good thing because I got to try a lot of cases, especially the sexual assault cases, but my colleagues didn't want anything to do with it. So as a new person, kind of read, I'll do it. So I did juvenile court for 7 years, and then I was part of the inaugural class of the federal defender's office here in the Eastern District of here in Milwaukee, doing both trial and appellate work. So I did that for 10 years before I applied to become a magistrate judge. I'm sure most of you here know that the magistrate judge application process, there's a merit selection committee, so there is merit to it, who reviews the applicants, and the district court judges, Judge Adelman and his colleagues, then select the magistrate judges. So I was appointed in 2010, so I'm very close to celebrating my 7th year on the bench. So that's the short, condensed version of it. I encourage those of you who are attending this panel, because you wanted to hear about how to become a judge, I highly recommend that you consider magistrate judge and other article judge position like bankruptcy judges. You are needed and wanted, and it's a wonderful way to serve the bench.
Thank you, Judge Joseph. And our next speaker is Judge Pedro Cologne, who I had the honor of serving with him for a while in the Wisconsin legislature, and now as a circuit court judge in Milwaukee County.
So, thank you. So, going along with the Caribbean theme, you don't have to be born in the Caribbean to become a judge. Like Nancy and I was born in Ponce in Puerto Rico and grew up Catholic, very Catholic, right? And so, when you're young and Catholic, they teach you, well, you just have to, your lifestyle, if you're going to be a priest or if you're going to be married or a single person, will reveal itself to you by some sign or some form. And I thought, oh, well, I waited for that sign, and it never came. And so I thought about that because, the presentation is, when did you first realize you wanted to be a judge? And I think it was about sophomore year of high school when I picked up Animal Farm by George Orwell. And I thought, I didn't want to be a judge, but I thought I was really interested in how power relates to people and how we talk about power, how we exercise power, and how we have these rules between the individual and the state. Obviously, I didn't think that on sophomore year while I was reading Animal Farm. Now I can tell you that perhaps it was there. It was the seed. So I developed an interest in government, all things policy, all things constitutional. And I was, we also didn't have a lot of money, so my mother suggested I become an engineer because I could get a job after 4 years in school. And that's what people did, and my brother did that. He was a medical technologist. But I absolutely was not very happy with that. So I transferred to political science, something I really enjoyed. And so then you get a law license, and nobody gives you a job, and you sit in your mother's dining room table and you say, well, this is what you work for. Use it. And so I used it. I opened up a law office. I got appointments. I did what I could to stay involved and to do the things that I thought I would enjoy. And I went to the legislature, learned a lot, and it was sort of, I don't think this path was not preconceived. A lot of it happened. So, but I now preside or sit in Branch 18 doing felonies. I think, criminal justice is probably one of the most exciting parts of law, and the one that we know the least about, I think. And so I really enjoy it. That's all I have.
Well, thank you. Thanks, Judge Cologne. And I'm going to move now into the broad subject, the state of the judiciary, which is a very broad subject. And I thought one of the important, probably the most important measurement of the state of the judiciary is the quality of the opinions, or the quality of the decisions, the quality of justice that comes out of the judiciary. And so again, let's start. Justice Tice, you see all the cases, or you see cases from lower courts in Illinois in your capacity as a reviewing judge. So I guess, how are they doing?
Great. As I told Lynn, I'm going to take his question and go where I want to go. Because this is where I wanted to start. Alexander Hamilton, I'm a man of the moment, Alexander Hamilton wrote in the Federalist Papers that the three branches of government, in theory, are equal. But in practice, the weakest branch of government is the judiciary, because it has neither the power of the purse or the power of the sword. So, where does the authority of the court come from? This is something that people have thought about deeply for a very long time. And a consensus that has arisen is the answer to that question: why are courts allowed to do what they do without the power of the purse or the power of the sword, is directly related to the public's trust and confidence in the integrity of the judiciary. Judicial independence and the public's trust are just either side of the same coin. The only way the court makes difficult decisions is in direct relationship whether the people trust in the integrity of the court system. Now, that sounds like easy words to throw around or maybe empty words to throw around, but this is the kind of language that judges use all the time. It's not just something on a coffee cup. The ABA model rules for judicial ethics that almost every jurisdiction has adopted makes it an ethical obligation for every judge to conduct him or herself in a manner that promotes the public's trust and confidence in the integrity of the judiciary. So this is not empty words. This is our life's work. This is what grounds us. This is our ultimate ethical obligation, and it is where our source of authority rests. So, where are we in the sense of the public's trust and confidence? As I probably am going to say in the next 45 minutes, I'm a pretty happy, sunny person. I think we're doing okay. Through our history, we have lots of twists and turns of how the public looks at the court system. Generally, I think we're doing okay. But I am concerned, and I have about 3 topics that I'm going to say very quickly that I'm concerned about. The first is I'm not worried about attacks on the judiciary, people talking to the president or whoever saying nasty things about judges. It's been going on for a long, long time. It just, a little bit of history and you can see things that Roosevelt said or whatever. I mean, this has been going on for a long time, so that doesn't trouble me. What does trouble me are attacks generally on institutions and cynicism about institutions, because that cynicism, that lack of faith generally with institutions affects all of us then in terms of our court system. And that's a national issue. It's broader than just being a lawyer. It's just broader than the justice system, but I think it's very real and something we have to be concerned about. The second piece that concerns me is an increase in a view of the court system as partisan. Now, there have always been, again, not new. People have been concerned about politics, whether it's on the federal or the state level. People have been talking about this for a long, long time. And organizations such as ACS and other organizations have tried to, how can we fix the system? How do we take partisanship out of our court system? We understand that there are a lot of elected judges across the country. What do we do with that? And it's something we've all been working toward and thinking about and trying to strengthen our system for a long time. What's concerning me is a lot of the reforms, a lot of the safeguards that we thought was the answer to partisanship and how to take that out of the judiciary are under attack. So, for example, each state's different how you choose judges. Every jurisdiction is different. A lot of states have what seemed to be a great reform, retention elections, where judges at the end of their term stand for accountability, and it's a yes or no, nonpartisan election. And that was supposed to be the answer to partisanship. Well, of course, what we've seen now all across the country is huge, dark money going into not election of judges, but retention of judges. This was supposed to be the answer. Well, guess what? It's not. So I think we have to think of new ways to address the issue of partisanship in our court system, and certainly the perception of partisanship in our court system. And that's my last point. That I'm really concerned that if we begin with the idea that the power, the authority of the court comes from the people and their trust in the integrity of the court, if that's been the shared value by judges across this country. I mean, you scratch something, the words just fall out of their mouth real fast. That's what we talk about all the time. I'm beginning to worry that there are members of the judiciary who don't embrace that value, who instead do see themselves as ideologues, who do see themselves as partisans. I can talk about, you asked me about Illinois, we're elected, I know where my colleagues were elected from. I don't see ideological differences at all in our opinions. I can point you to cases where you have no idea how that person was chosen, what party they're from. But I fear that judges themselves are getting swept up into this partisan moment, and we're losing that commitment, this higher commitment that we have to ultimately serving the people. And what the people want are not partisans, not ideologues. They want, this sounds so empty, fairness. And if the people start believing that we're not being fair, then we've lost the authority that comes from that. And that's what I'm worried about. But I have happy news later about other things.
Well, let me skip over to Judge Cologne and see, do you have the same view of, are you sort of upbeat about the state of courts in Wisconsin and the quality of opinions?
You can say it. No, you don't agree with me.
Well, I agree with the fact that I think most people don't want people just ruled by ideology as they are concerned with deciding cases. I think we can all grasp that, and that's a healthy attitude to have, and I think we're all taught that in law school, whether we like it or not.
Go ahead.
Did you say Nancy or Pedro?
No,
No.
go ahead.
Go ahead.
Did you want me to talk?
Yes,
Oh,
we do.
okay. I'm not going to overrule Judge Adelman. But you see, I think, frankly, to me it boils down to the way in which the mechanism for electing judges has substantially changed in the last 5-10 years, and where there used to be an understanding about how judicial elections were conducted. I think that's no longer the case. And I think ultimately we're getting Supreme Court justices that are frankly not ready to be Supreme Court justices. And what gives me the knowledge to know that, or to say that? Well, I understand the legislative, and I see ex-representative from John Richards here, and I understand what the powers do when they're talking about a legislative agenda. But when you're talking about the courts, I think that shouldn't be the primordial understanding as to where courts go. Now, it's one thing to say it, it's another one to do it. Because we all get elected in an election, and people have says in elections, and you should participate. I don't agree with the way in which money is handed down to these elections. I don't. But you should be able to understand how it works. And to me, it just seems that we are in a place where the concerns and the prior elections, whether won or lost by whatever candidate, those rules are no longer applicable, which in turn gives elections to, I think, people who are more politically beholden and not willing to say no to, I mean, this I learned from, Congressman Obey, right? If you're not willing to make your friends upset, you shouldn't be in a position of leadership. And that's life. And I think we're at a point where more and more people are unwilling to make their friends upset. And when it's right, and you should make your friends upset, you should. And so that's what I think is primordially the challenge we have going ahead.
Thanks, Pedro. Judge Joseph, you're in the federal system, which doesn't have elections, although many people would regard the federal system, or the Supreme Court, especially after what happened with Merrick Garland and holding his appointment up for a year, as every bit as partisan as a system in which there's elections. You have to pay attention to district court opinions, to Seventh Circuit opinions, to Supreme Court opinions. Do you want to add anything with respect to the federal system compared to some of these other comments?
Yes, I guess at the trial court, I'm paying attention most to the Seventh Circuit, which in many cases, as you know, is the court of last resort in the federal system as opposed to Supreme Court. I think all of that matters. I think, Judge Adelman, I think not so much of what I think, I worry about what the public think, as Judge Tice was saying. We know what we do as judges, and we know how we arrive at our decisions, but the public does not always know. And when things seem so partisan, then they think it's because of partisan reasons. So I think we do have to pay attention to that if we want the public to have confidence in us. So that's one of the things I worry about. So what can we as judges and lawyers do to kind of help educate the public about how we decide cases? What exactly are we doing? Is it because there's a D or an R behind our names? Whenever there's a decision, something in the news about a federal judge, I always take note. They would say, Judge Edelman appointed by President so-and-so, or what the party affiliation is. I think those things feed into the perception that what we're doing is political, even at the trial court level, although the appellate courts are different, I think.
Did you want to add something, Pedro?
I don't think that perception, in many ways, that's become reality. And so when you talk to people and you understand that the Federalist Society essentially has a veto on whoever gets appointed to any Supreme Court in the United States of America or any state court, that's the reality. That's been reported. That's not perception anymore. And that's troubling, right? I think we all agree. But I don't think that changes the reality of what the mechanisms by which we're undergoing justice. And we can talk about, everybody has an example. And so I think together with the perception, at least to the people that report on it, is reality. You know, when you talk to a reporter, say, "What did you put that in the story?" They'll tell you, "Well, it's a fact. That's why I reported it." And so if it's reported that way, it must be a fact. And then you look back and you have confirming conversations, and it is a fact.
Well, there's clearly no denying that on the federal side, although we're not elected, that it's a political process. That's the reality of it, and that's why it matters who's making the decisions and making the appointments. There's no denying that at all. And I don't think that's incompatible with worrying about the public's perception and how we can try to get their confidence that it's not just about that.
I think one of the things we think about is, in talking about public perception, is how we present ourselves. And certainly, Pedro, you're right, when you're talking about the press likes the game, right? They like binary stuff. Are you a Republican or a Democrat? And who you're pointing at? I mean, that may be their point of view. And it may be that's how generally the other two branches function. So that's how the press looks at what the judiciary does. Our challenge is to communicate that we understand that we are very different in what we do from the political branches, that we're not driven by partisan ideals or ideological ideals. So somehow we've got to get around that kind of simplistic view that all three branches of the government function the same way. One of the things we talked about, and Nancy and I have talked about this a couple times, one of the things we talk about is procedural fairness and being transparent. So you're right. If people think she was elected as a Democrat, no wonder she decided this way. He was elected as a Republican. He was appointed by a Republican president. No wonder he decided the case that way. If that's the construct that people are working under, then we have a problem. But I think that's why we as judges have to embrace this problem and say, okay, how do you get around that without throwing your hands up in the air and shaking your head? And certainly the idea of procedural fairness is one way we talk about that. And when we say that, what we mean is it's not just what we do, but how we do it, how we treat the people in front of us, how we craft our opinions. I mean, literally, how you explain, in your opinion, how you got to the decision you made. If it's clear, if it's logical, if it's based on precedent, then that alone can dispel some of this cynicism about what the court does. And so we can talk about it in terms of, big constitutional issues, or we could talk about the fact that most people's experience with the justice system is in the state court. And most people's contact with the court system is not with constitutional issues or, big money cases. I circulated a study done by the National Center of State Courts that said in terms of civil cases in our country, 64% of the cases are contract, being mortgage foreclosure, debt collection, and landlord-tenant. So that's where most people have contact with the court system. So somehow there, we have to figure out how we deal with the people who use our court system and communicate to them that what is happening to them is not driven by partisanship. It's driven by a commitment of judges like us to doing justice.
Related to that, I know is the issue in terms of perception of courts is the issue of whether judges somehow reflect the way the country is in terms of its population. I guess I'm referring to an issue that's commonly, I think, known under the rubric of diversity. And there's been a lot of work on that particular issue lately. I know, Judge Joseph, you're pretty much, you've done some work in that area yourself. You want to talk about that a little?
Sure. A lot of people have been talking about diversity. I bring show and tell. There's a recent report by the Brennan Center for Justice. It's available online and it's free. You can download it. It's not very long, dealing specifically with the federal courts that I recommend to you. And I know ACS has done a report called the Gavel Report that's also available online. On the federal side, I guess definitions are helpful here. When we talk about diversity, I think we usually think of what we usually go to, racial diversity and ethnic diversity. But I think I'm talking about in terms of that for sure, but I'm also thinking about in terms of different background experiences. I mentioned that my experience was as a federal defender, different socioeconomic life experiences. So I would put all of that in terms under the diversity umbrella. On the federal side, I think for the Article 3 judges, the district court judges, the appellate court judges, on some diversity issues, they're doing better. There's been improvement. But for magistrate judges and bankruptcy judges, surprisingly, we are lagging behind. I say surprisingly because I think it connects back to our conversation. The Article 3 judges are political appointees. The magistrate judges are and bankruptcy judges are appointed by other judges. So it's very interesting to me that we're lagging behind in terms of diversity. For specific numbers, for example, for magistrate judges, in terms of gender, we're doing pretty comparable to the Article 3 judges. 37% of full-time magistrate judges are women. That's similar to the Article 3 judges. But in terms of race and ethnicity diversity, for magistrate judges, 14% of magistrate judges are people of color. So 80-something% are white and 5.2% did not report. For bankruptcy judges, it gets even really sadder. 7% of active bankruptcy judges are people of color. 7. And 86.6% report as white and 6% did not report. So that's an area where we should pay attention to because I think it matters. I think we want our bench to reflect our communities in terms of race, ethnicity, all the different backgrounds. And it relates to what we were talking about in terms of the perception of the courts. The people who are coming to our courts are diverse. And I think they want to see their bench to reflect back their communities.
Could I make another comment? And yes, I mean, I 1,000% agree with everything you say about people coming into our courtrooms and trying to decide if this is their justice system. And a part of that is whether the person who's on the bench reflects, in some way at least, each person's background. There's a lot of talk that goes around. I'm sure you're going to hear that you're familiar with the term of implicit bias. But I should let you know, this is like the issue in my world. I mean, we have implicit bias training all the time. I sort of roll my eyes at one more implicit bias program going on because we know that this implicit bias is real. It's not evil. It's human nature. Academic studies start with a book called Blink by Malcolm Gladwell, and I think it's 2009, 2005, national bestseller, and it was Blink, thinking without thinking. Okay? You see a red light, you put your foot on the brake. You don't think about that. It's just gut instinct. we live a lot of our lives that way. You see someone who's like you go, yeah. You see someone who's not like you go, it's a natural human reaction without thought. It's not evil, it's not wrong, but it's real. And for decision makers like us, it's something that we've got to be very, very aware of. So there's a lot of research that we're beyond that. We assume every one of us has those same kind of reactions. So what do we do about it? And the research that's going on now is about the antidote, again, is deliberative thinking. Not thinking without thinking, thinking about your thinking. And so how do we encourage in our court system judges to take that extra step of thoughtfulness and say, this person is not like me. All right, fine. What else is going on here, and how do I craft my decision around this person? The newest research, which is kind of fun, is about how to create courtrooms that will encourage deliberative thinking for judges. So they've done a lot of studies where if it's a courtroom where there are people walking around and the judge has to multitask and all that, that judge's bias will show. And when you have courtrooms or a reviewing court where the court has time to think about what they're doing, the bias drops. So these are not abstract ideas. This is core to who we are as decision makers, as doing justice, as decision makers, is being aware of the implicit bias we all have and to work towards solutions as how we minimize that in our court system.
Judges, do you have time for a quick follow-up?
Absolutely.
Sure, go ahead.
Yeah, on the issue of implicit bias, I also brought show and tell. The ABA just published a book called Enhancing Justice, Reducing Bias. It's an anthology of some of the latest research and articles written by both judges, lawyers, and academics on implicit bias. I really recommend it to you. I think it's a really well-done book. Not only does it talk about the problem, we spend a lot of time talking about problems, but also talk about what judges can actually do, some of the things that Justice Tice already mentioned. On the question of diversity, if I could just return back to that for 1 second with an anecdote that I heard, which kind of stuck with me. Judge Bernice Donnell, who's a judge on the Sixth Circuit Court of Appeals, she does a lot of talk on implicit bias and on diversity, and I heard her tell this story, and I thought it was so demonstrative of why it's important. She talked about starting out in state court, and as a state court judge, she's an African American woman. Her courtroom deputy was also African American. Her staff and the prosecutor that day who was assigned to her courtroom also happened to be an African American guy. The public defender who was assigned to that court was also African American. And in walks in a white defendant. And so everyone in the courtroom is black except this one white defendant. And he kind of takes a look around the room, and then he says, Judge, can I get an adjournment here? I just want to get an adjournment. She's like, okay, sure, fine, I'll delay it and you could come back. And then she said the next day, the white defendant came back, this time with a retained black lawyer. And he said, well,
That's great.
If everybody's black in here, I just want to increase my chances. So we laugh at that, but it happens in reverse all the time in our courtrooms, right? The black defendant, which is the majority of criminal defendants in any court, right, state or federal, or Latino, so a person of color. And he walks in, the judge is white, the marshals who are escorting him are white, the courtroom deputy. So that's the scene he's seeing. Whether or not it's going to change the outcome or not, that's not the question. But again, going back to the perception, whether the person feels that they're going to get a sense of justice. So it was a funny story. I wanted to share it with you.
Incredible.
Judge Cologne, you want to add anything?
Other than my name is Pedro Cologne and I have to run electorally, it's a tough walk some days. I don't think I can add anything that hasn't been said. I will just add that, in this diversity conversation, and I'll go back. We truly need a diversity of views as to what the Constitution has in store for all of us. And so what I mean by that is that if you're in positions of meaningful decision making, not only do you have to understand the population as a whole, but you can't couch everything in an ideology. And I think, I've said that before, but it really, to me, I think, obviously for all kinds of reasons, I think that's a concern. And it's happened for many reasons. But, ultimately, you need a sound understanding of what a progressive constitution means for people. And if people can't understand that and express that as they go into their roles, then you're essentially going to have somebody who doesn't really understand why they're deciding cases. So I think, in this diversity of conversation, I think that a primordial understanding of every judge understanding what a progressive constitution means. Because I think we, whether you like it or not, we all understand what Clarence Thomas thinks about and where they're coming from in the Constitution, perfectly legitimate, but doesn't really apply to what I think America should look like, should feel like, and how it should be interpreted.
Could I turn to another issue, another concern that
Sure.
I think most judges have, and that is that buzzword would be access to justice. We did a recent study in Illinois. I'm sure other states are doing the jurisdictions are doing the same kind of thing. But in our civil courts, in 63% of our cases, at least one party was not represented by a lawyer. In some areas, up to 80%. People do not have lawyers. They can't afford lawyers. Remember, I told you before, in a civil court, 64% of our cases are debt collection, mortgage foreclosure. Hello, they can't pay their mortgages. They're not going to be able to pay the lawyers. And so what we're seeing in our courthouses, both federal and state, all over the country, are people coming without lawyers. In the civil cases, obviously, we have Gideon, and we have lawyers for people charged with crimes. But suddenly, our system is upended. Our system has been created to be an adversarial system, right? You have this balance of lawyers on both sides representing people's interests. Suddenly, that's not what we have. That is not the court system we have anymore. And so people are struggling. Judges are really struggling to figure out what our role is. We can't represent each one of these people. That's not our job. In terms of fairness, again, how do we find our way? And the other piece of this is when we're talking about diversity. Another way to look at it is we have a lot of people who don't speak our language. We have a story I hear all the time. One of our chief justices, who was real concerned about access to justice, went to our biggest courthouse in Chicago, 26th floor, high-rise downtown Chicago. And he walked around looking for signage, and everything was in English. And he found one sign that was in Spanish. He didn't know Spanish, so he had to ask somebody to translate for him. And the one sign in the entire courthouse, the high-rise building, that was in Spanish said, "Judges only, keep out." And that's our message to people, keep out. So, that's a symbol of a larger idea that we have of people who don't speak our language, not just Spanish, but who are not lawyers. And so again, where does the perception of cynicism come in? People come in the past, they had lawyers. The lawyers could guide them through the system, explain the system to them. Today, in these cases that we see all the time, people don't have lawyers. Access to justice is, to me, one of the key issues that everybody has to have a concern about as to how we address these problems of the public's perception breaking down of our courtrooms.
Question.
Well, related to that is there's a whole litany of issues revolving around, I guess you could say, poor people. There's the whole issue of cash bail, which has become very important and much discussed. There's the issue of mass incarceration, a term which nobody ever heard of until about 10 years ago when Michelle Alexander wrote a book about African Americans being incarcerated in masses, and then that has huge other kinds of effects, including the rules about not being able to vote if you've got a criminal record. And then there's also the issue of, you were talking about how most people, when they come into the courts, the contact with courts is state courts. I would go further, it's also municipal courts.
Mm-hmm.
And people go get traffic tickets and they don't pay their forfeiture, and then they wind up getting, in many cases, unconstitutionally, but never mind, they get committed. They get put in jail for non-payment of fines. In some communities, Ferguson was probably the most well-known. It turned out that they were supporting a good chunk of their budget based on this kind of police work and municipal court work. Are we doing anything to deal with that in a constructive way?
I think there's a revolution going on. There's nothing short of a revolution. And Michelle Alexander is one of my greatest heroes, because I agree with her. I think she started it. There's a real different tone about poor people in our court system in the last few years. The legislatures have caught up, hopefully in Wisconsin. You can give me some examples where they have, but we're seeing it all over the country in each one of those areas you're talking about. Pretrial reform is everywhere. It's the hottest topic in every state that I know of. When you talk about mass incarceration, the model that everyone talks about today is community corrections. Of course, that means a shift in appropriations away from building prisons toward strengthening probation officers and drug treatment centers and that kind of thing. But it's real. It's not just everyone in this room hoping that could happen. I see it in every state I've been looking at. There is this movement suddenly now, for whatever reason, of being very aware of how poor people are affected by our court system. It may be that there's another piece. They may be the last people who come to us. Because today, big corporations and other people are bailing on our court system, and they're going to arbitration and mediation. In some ways, another fear I have is that ultimately the court system is to be the last resort only for poor people. The rich people and the middle class people are getting out like crazy. So we have to figure out what we do when our court system turns out to be the poor people's court. But I completely think that there is this change that is in the air all over the country, where it's not so unusual for people to be talking in the same way that you're talking about here. Do you see that too?
I think on the federal side, there was some proposed and surprisingly bipartisan proposed legislation to address some of the federal criminal laws and mass incarceration issues, but I don't think there's momentum for any of them to go forward. But it was nice for a change to hear both sides talking about it. Although some of it may have appeared to me to be motivated by concerns about money, how expensive it is to incarcerate people and keep them incarcerated. But I haven't heard anything recently or read anything recently about any of the proposed legislations that were talked about going forward.
No, you're absolutely right, and I'm sure you know too. I mean, there was a big momentum about a year ago, bipartisan legislation on the federal level, that just died with the election.
Well, I think, the court system is becoming, my mother was a teacher up the street on Wisconsin Avenue for 27 years. And the latter part of those years, after the so-called coke epidemic, it was really hard to attain achievement by these kids. And she'd say, well, what can I do? I only have until 2:30, 2:45 to go on the bus. It's really the home life and so forth. And so I think as a young person thinking, well, you're teaching them. I mean, really, something's got to be done. I think the court system has sort of become part of that. So now we have our court system becoming the depository of the system-wide failures for a number of, mostly for the poor. And so if you have that kind of system, and then you talk about things like minimum wage. And my point is, are we just chasing the conditions and sort of band-aiding ultimately the inability of the rules to be fair and be applied fairly in other realms, whether that is in how people make their living, how collections are executed, how we talk about living standards in terms of housing. And we've had a book named by Evicted. I always say I lived that for a year because I was in small claims. And so all this instability, I think the courts can cope with, and I think we have a lot of judges and the judiciary can cope with. But I think these are larger questions about the Constitution, whether a city can enact a minimum wage law, and to what extent should the state respect that? Or how is it that we fund schools? And Judge Edelman understands this probably much better than I do. He did it for much longer. But these are the questions that really, I think, are sort of under all of these efforts to equalize municipal court and equalize, in Milwaukee, the parking enforcement is. That's my pet peeve. I shouldn't talk about that.
So we got about 10 minutes, so let me open it up if anybody in the audience wants to. There's a lot of things we haven't talked about. Oh, go ahead.
Hi. Thank you for sharing your thoughts with us today. I am a law clerk in Stearns County, Minnesota, so all of the issues that you guys have brought up in implicit bias, access to justice, pretrial reforms really ring true to me. And I was wondering if you have any advice. There's so many of us who work within the judiciary but aren't judges, haven't made it to that point in our careers. What advice do you have for us moving forward and trying to bring these reforms to the judiciary on the ground in this exact moment when we have a lot of opportunity to do good for our communities?
Maybe we'll broaden a little bit to lawyers in general. We've got a lot of young lawyers, a lot of people who are really committed. That's why you're all here. You all came to Milwaukee today because you're committed, right? So we kind of spun out some problems. You probably have your own view of what some of the problems are with our court system today. So then the question is, okay, judges, that's great. You guys are committed to change. What can we do? Of course, one thing, and I know Pedro would agree with this, vote. Elections have consequences. Staying home and being angry doesn't work. As I recall, that's what President Obama said in his farewell address, is if you don't like what's going on, run for office or sign a petition. I mean, get out there and do something about it. But in terms specifically of our court system, part of it is this role that lawyers have as being part of a larger justice system. It's not just judge-led. There are only X amount of us. An awful lot of lawyers out there who can speak and advocate for these larger issues, being part of the movement of access to justice. Now, part of that is pro bono work, a lot of people volunteering to take cases like this, but a lot of it is systemic that lawyers can be part of to make changes in our system so it's more accessible to people, it's procedurally more fair, and it's more diverse. So that's how I kind of focusing on those kind of values.
I would add to that, I would like to see lawyers and judges working more together we're kind of in here speaking to each other, speaking to the choir, but how can we, judges and lawyers, create forums where we can educate and share with the public about the issues facing the court, what judges do, what courts do, and what lawyers do. So branch out more to just beyond our lawyer judges community and engage the community, because it's their courts, it's their court system.
I don't have anything to add.
Could I have one thing? Can I say one thing? Here's a horror story that turns into a wonderful story. You might recall that I think 2009, the Iowa Supreme Court was the first court to uphold same-sex marriage. And Iowa is a really well-respected court, very moderate. Yes, they have retention elections, merit selection, all that kind of stuff, but very well-respected, and they just did what they thought was the right thing. Within a year, 3 of the justices were up for retention, and huge money poured into Iowa, and they all lost. And they were devastated. And I talked to some of these judges. They said it was like a death in their family. And they got together with the bar and said, okay, what specifically can we do to reach out to the community and create these events where we can demonstrate that we are people committed to justice and not being idolites? And they went out and they had court hearings in high school gyms, and people were on TV, and lawyers wrote articles, and there was this huge coming together of the bench and bar in defense of this big idea, not the individual judge, but this big idea of doing justice. The next election, one more of the Supreme Court justices was up for retention. More money poured into Iowa, and she won. I can tell you the same story happening in Kansas. I can tell you the same story happening in Tennessee. Money is coming into these elections, and now people have rallied together to try to figure out how to fight back. And in Tennessee, 3 Supreme Court judges, 10 appellate court judges, the Koch brothers, they all won retention. In Kansas, Sam Brownback, all that, they tons of money against all of the, and again, trial judges all the way through. Big money came after them, and the judges all won. Because, not individually, but because the bench and bar came together to tell the story that when we say we're working for justice, we mean it.
Thank you. Question?
Question and sort of a comment. In the program, I want to thank Judge Tyson for bringing up the subject of dark money. In the program, it says one of the things we've been talking about is how lawyers can respond to attacks on the integrity of the judiciary. I would say as how progressive lawyers can. And the key is to fight that. And the chances are, I'm sorry to disappoint everybody, that most of the people in this room will not be judges. They will be lawyers who have to help in that process. And it can be won. And it has a salutary effect. Winning the damned election has a salutary effect. Because just as losing it has an in terrorem effect on the judiciary, winning those races means it's not going to be that easy to raise that kind of money a second time or a third time. And we can do that. I think on the other question, I guess, or comment would be in terms of the judges themselves. There is this inordinate fear of Canon 7. You can't promise, you know what I'm talking about. But there are ways to be able to...
You mean you can't talk about how you're going to decide cases? Is that what you mean?
Yeah.
Canon 7? Okay, go ahead.
But there are ways to transmit your values. There are ways to transmit your life stories, which the public loves to hear about. And that can tell an awful lot to people. But the key point here, I think, is that for the people in this room, is we have to be willing to get our hands dirty. And I don't mean dirty tactics, but we have to get into the grit of raising money and going out to community groups, doing all the things that Judge Tice said. And remember that most states have essentially got an election process of one sort or another. And it's not going to be structural changes or process changes or all these things that we sit around talking to each other about. It's winning the damned election.
Thanks. Yes, sir.
I'd like to hear from each of you an insight that you've gained since taking the bench that you wish you would have had before you took the bench.
You have been on the bench 20 years. You start.
Oh, man. An insight that I've gained since being on the bench. Well, let's see. One thing it sort of follows up something that Justice Tice said. One thing that I've noticed over the changes since I've been there is that when I first got on the bench, there was a lot of business litigation, businesses litigating against each other, and I was involved. I'm somebody who's not I don't hesitate to get involved in settlement, and I did a lot of that. In the 20 years that I've been on the bench, I found it much more unusual for corporations and businesses to it's like they're scared of juries. I mean, it's like the juries are these, who are these jurors? We don't know them. They're going to come in and decide something. So I've been, and there's much more arbitration and much more, some of the Supreme Court decisions about, that arbitration takes the place of some of these contracts of adhesion where consumers can sign a contract and it has in there that you have to arbitrate, or employees. So I guess I've seen a lot. I guess I'm making a couple points. One point is that businesses are much less likely to be interested in using the federal courts. And the second thing I've seen is that there's a lot more arbitration, and it's being forced on people who shouldn't have to give up their right to go to court. And it's being forced by the U.S. Supreme Court, just one of many areas in which they've done great harm to the country. So, anybody else? Insights?
It's a lonely job. Maybe I knew that, but it's a real isolated, lonely job, and it's real easy to get into your little world in my ivory tower and stare out the window and think big thoughts and lose sight that I'm changing people's lives. You got to work at it all the time.
Thanks, Justice Tice. I saw a sign that went up said "Stop."
Oh.
You
said we could finish.
We'll have a little more then. Okay, go ahead.
No, I agree. I mean, if the question's from the perspective of someone who's thinking about being on the bench, I think it is worth thinking about the loneliness of the job, or the isolation, and that judges actually have to make an affirmative effort to go out and engage with lawyers, and more importantly to me, I think engage with non-lawyers, engage with the community, and kind of stay real as to what's affecting people's lives and what's going on with people's lives, stay educated that way. The other observation I made, I have the least experience on this panel, being on the bench 7 years. I try to attend judges training and workshops, and it's interesting when I talk to colleagues all around the country. Sometimes I meet people who who strike me have not lived in the real world or have not practiced in the real world. So I think for you lawyers, that tip is spend time, educate your judge, because you don't know what his or her background is in terms of real life experience.
I would just add, really, the urgency on the criminal justice side, right, which is something that state courts do every day, all day, and very intensively. The urgency of making sure we're doing this correctly, fairly, we're not increasing incarceration unduly, we're actually bringing factors that matter into public safety. That concerns me every day. I have to sentence these people, and frankly, the efficacy of sentencing is really, and the urgency, because, and the reason I came to this conclusion was not only through the judging, even prior to the judging, that is, before I rotated into criminal court, there was a federal court judge in the Eastern District who retired, and she was lamenting how she had sent so many young African American people to prison for drug possession or drug crimes, and how that community was devoid of really male role models. And I thought, well, I'm a judge, I'm certainly not going to be part of this. But to Justice Thai's comment, it takes a lot of effort, and it takes a lot of effort by the attorneys, it takes a lot of efforts by the judges and everybody who cares about these things. So the urgency of it, to me, is something that I now take with great responsibility.
Well, I want to thank the panelists and thank you for your